Okay. Testing 1 2 3. Testing 1 2 3. Test test test. Testing.
Morning, everyone. We have 9 cases on today's argument calendar, and we'll begin with Appeal 24-2464, Devontae Abbas versus the City of Hobart. Good morning. Mr. Luarczyk?
Yes. May it please the court, esteemed counsel. Today's case, first case, is about whether or not the City of Hobart can be held responsible for the constitutional violations under the 14th and 4th Amendment that my client endured at a police stop in 2019, and whether that occurs is under the framework provided in Manel versus Department of Social Security.
Can I just clarify with you, please, before you go further? You are only suing the City of Hobart here, correct?
Correct.
You are not suing any of the individual officers?
No.
Okay. Thank you.
You're welcome. The facts, if presumed in favor of my client, which we must do at this stage, which is summary judgment, are disturbing. In 2019, in January of 2019, my client was forcibly removed from a police car and stomped upon. All charges were voluntarily dismissed by the city. 4 months later, in May of 2019, my client was driving in the city and he was being followed by a police car from the city for a mile, very closely. During that mile, by the officer's own admission, no violations occurred. After that mile, he drove off into a parking lot because he was understandably nervous, and he collected himself and drove back to his mother's. He missed his mother's turn initially because of his nervousness. The police officer here, Officer Kissy, curbed him, and the reason why he was curbed is contested. The reason the officer gave is a shifting reason. In some places because he drove suspiciously, but ultimately the reason given was that he didn't use his turn signal correctly, which my client also denies. He says he used it well in excess of the 200 feet required under Indiana code. After he was curbed, Officer Kissy came over and started to ask him questions, and my client recorded the conversation.
Mr. Luarczyk, even if we accept and credit everything that you're saying, which you've laid out in your brief, if you return to Judge St. Eve's question, you have to show that the constitutional violation was committed by the defendant, not by one of its employees.
Correct.
And so I think the way that you're attempting to do that in your brief anyway, because you have to, there's no vicarious liability under Monell, no respondeat superior liability, is by focusing, or at least in your argument, you reference a lack of training.
Correct.
Okay. What does the summary judgment record show regarding the content of the training that the City of Hobart provides to its officers?
Well, both officers said in the 8 years preceding the stop, they received no training on racial profiling. And
does the record show more broadly what training they did receive? Because in other words, it's hard to believe that a municipality provides zero training to its police officers. The more narrow point you're making about being racially conscious and not discriminating, I understand. But does the summary judgment record inform us as to what training overall the officers receive?
Yes, the officers, or Officer Kissy in particular, went into a description of what his training was, and he specifically said he never received any training on racial profiling, and that was echoed by the other officer at the scene. And assuming the facts in my client's favor, which I don't even think you have to do because they admitted they had no training. The training was deficient. Continuing on with the facts, he was told to get out of his car.
If we could, please, I want to go
Sure.
continue with your training theory, because you're seeking municipal liability based on a theory of lack of training, correct?
Correct.
And in order to get that, you have to show that there was a pattern of reckless conduct that the training was needed for. What kind of a pattern can you show here?
You actually don't have to show a pattern under Monell if the risk of the constitutional violation that the defendant failed to provide training for is obvious.
You're relying on canon
And
for that,
Yeah,
correct?
and
canon is
JKJ.
such an extreme case that, do you need canon to prevail here?
no, I think JKJ also provides that.
Let me rephrase that. Do you need to proceed under the so obvious standard in order to prevail here?
No, I would argue that it's in an alternative argument.
Then your alternative would be to a pattern of criminally reckless conduct or pattern of reckless conduct. What evidence supports that there was a pattern of reckless conduct here, that the Hobart should have been on notice that they needed training?
Well, in both incidents, there was no form of accountability, no body cams, no dash cams.
Have you, in the interest of time, we don't have a lot left. I don't mean to cut you off, but does the record support any other incidents along these lines other than your client's prior experience to show a pattern?
These two instances, no, these are the two instances that was argued below. I wasn't trial counsel below, but those are the two instances. Okay. I would contend that racial profiling is so systemic in society. It's far more obvious than the fact patterns in canon and JKJ. I mean, you have to live in a cave not to understand that racial profiling is a systemic problem in society. And there is a direct link between the Equal Protection Clause and Fourth Amendment arguments and the failure to train. These officers didn't know the boundaries of racial profiling, and you would think that that's an obvious or inherently a truth that all officers should know without training, but it's not. I mean, yesterday I was listening to the radio, nerding out on NPR, and I found out that an ICE agent was interviewed and told the journalists that they don't target Caucasians. So it's an ongoing problem, and it was an obvious problem and a predictable problem. It's in an urban setting. These officers are going to encounter people from different races, and so it's not something that the municipality here could just discard and blow off. If there's unless there's any other questions, I'd like to reserve my 1 minute and 41 seconds for.
Yeah, very well. Okay, we'll hear from Mr. Friedman. Thank you.
Thank you.
May it please the court. Let me address initially the statement of facts by my esteemed colleague. He talks about my client got stomped. He's referencing a January 2019 incident, and the court is able to take judicial notice of the fact that that incident went all the way to a state court jury that found against Mr. Abbas. It was a defense finding on behalf of the city of Hobart. It was appealed to the Indiana Court of Appeals, which also upheld the city of Hobart. No liability in that case. So let's be clear. In this particular case, there's not even a physical encounter. We've got a 23-minute total stop at this point, and there is no issue of any kind of a physical counter or anything else. And so as long as we're going to be referencing that January 2019, and it's referenced at page 18, 21, and 48, it's fair game. He's using it, of course, understandably, to try to set up a notion of a pattern. practice. And he simply cannot indicate that because in the summary judgment record, there is no evidence in the record of any kind of pattern or practice of racial discrimination on the part of either Officer Kissy or the responding officer as well, Corporal Garber. Officer Kissy had had 8 years with the department, no write-ups, no mention of any kind. We all know that in order to establish custom, pattern, practice, there's got to be some history of problems with this department. And respectfully, Your Honors, there's nothing.
Was there any attempt to pursue discovery along those lines?
It was very limited. The January 19 incident got bumped because of it was time barred, and so it was sent out by the federal district judge at that point. And so then they brought their state court claim. Even in this particular case, while they've alleged Fourth Amendment, Eighth Amendment, and 14th Amendment, discovery was very limited. But there is nothing in the record at which the reviewing judge had to indicate any kind of pattern or practice of racially discriminatory activities on the part of the Hobart Police Department. As the court is aware,
Mr. Friedman, what are you relying on as the basis for reasonable suspicion to pull the car over? The district court relied on the fact that he didn't properly use his signal.
Yes.
You seem in your brief to be relying more on the fact of the way he was driving and engaging in unusual behavior.
as Your Honor is aware, it's got to be a reasonable suspicion of a traffic violation, not probable cause, and an objective basis for a reasonable belief, and that's fair. I think there were a number of things. Driving very slowly, number one. Out-of-state plates, number two. Based on this officer's experience, the turnaround in the apartment complex raised some suspicion, but the turn signal misuse is the key. The turn signal misuse is the key because we had the left signaling, then the right signaling, all of it done under the 200 feet required under state law at that point to make a turn signal decision. And I think the reviewing judge, district court judge, found that helpful because as the court is aware, you've got the two inquiries: was it lawfully initiated? And once that's determined, was it unreasonably prolonged?
Is there anything in the record that corroborates the turn signal not being done in a timely fashion? I know the officer testified to it, but the ticket or anything else, the arrest report, does anything support that?
And that's the problem here. They don't even have a ticket. There's not an arrest. There's not even a warning. 23 minutes, and certainly not unreasonable in terms of time. The canine was on scene within 6 minutes of initiating the stop. And there is no indication of any kind of prolonging it, but as a result, there's no ticket. What we've got is the officer indicating we had the turn signal
Was
issue.
there any write-up of this at all?
We've got his narrative that's in the record. That's correct.
By narrative, is that something in written form?
Yes.
I didn't see. Okay. And does he indicate the turn signal
Yes.
in that narrative?
He did. He did. He did. He was complete. He's a good officer. He really did it by the book. And despite counsel's valiant efforts, there's no way he's able to turn what is essentially a sow zero of a case into a silk purse. There was simply no constitutional violation in the initial stop. The queries for license and registration were appropriate. The request to step out of the car and move unrestrained at that point. The canine's external sniff of the car. The canine then had the positive alert, which then prompted the search of the car, and then there was a pat-down. One of the things they've complained about was the pat-down. Again, he followed standard procedure in terms of...
I'm not sure why there's so much focus on whether there was a constitutional violation in this individual case. Because, as we've had confirmed, the police officer that effected the stop is not named as a defendant. And the only theory of liability is Monell.
Right.
And for better or worse, the justices have set the Monell standards pretty darn high. So isn't all of the discussion about the car stop neither here nor there?
It is, but we've got to at least flesh out the record. But I would agree with Your Honor that when it comes to establishing a Monell violation, the bar is set high. And it would have helped them had they had any kind of evidence in the summary judgment record of lack of training, citations of the department, citations of other officers. Your Honor, respectfully, there is nothing in there. And and I can understand why Judge Lund did what she did, because in terms of the Monell analysis, as the court is aware, I mean, you've got to remember the protected class, similarly situated, treated differently, show the decision maker acted with discriminatory purpose and motive. Fortville teaches us that. Your case, the Seventh Circuit case from 2011, it is a high bar. And you've got to show some intent. And so they're trying to bootstrap that January 19 incident in to try to show that there was some sort of discriminatory intent on the part of the department. Different officers even responding at the January 19 versus the May 19. He's never received any kind of write-ups. And to indicate that in, with 8 years, there were no complaints of disparate treatment of black versus white motorists. I mean, if I'm making a Monell case, I got to show some sort of a pattern, something in terms of a customer practice that has been enabled, authorized by the governmental entity, and respectfully, Your Honor.
Counsel, something you said just caught my attention.
Sure.
You said no complaints against this particular officer?
Yes, sir.
Okay. You said a couple minutes ago that discovery was limited. Did plaintiffs seek discovery below on traffic stops by race for
No.
any period of time?
Candidly, they went through a number of different counsel, and no, it was limited in terms of, but there's nothing in there. What they did seek evidenced nothing in terms of a pattern or a practice on the part of the department that would give cause for concern.
But I guess my question's a little different. Did plaintiffs seek evidence, discovery on a pattern for a particular period of time for the City of Hobart's police department?
No.
They did not?
No.
Okay.
I mean, that's up to them. I can
I
only-
understand, but I think counsel said he was in counsel below, so I thought
know.
you might know better.
I got
If
it.
you objected, for example.
No, that's exactly
Okay.
right. No motions to suppress, no motions to limit discovery, but it's not our job to do their job. I mean,
I understand. I'm just trying to understand what the record below and what was sought
Fair
from
enough.
the city.
fair enough. Again, we think that with the record that's before the court, they've just not met that burden, which is very challenging to meet, as we all know, under Monell, and we would respectfully request a finding on behalf of the City of Hobart.
Okay, very well. Thank you.
Thank you.
Mr. Dwarchik, you have some time left. You're welcome to use it.
See if I can speak as fast as I can. I think the factual rendition forgets what Rule 56 requires, because all of those factual assertions, every single one was contested by my client, including the very important notion that he didn't turn his turn signal properly. That provides the basis for the Fourth Amendment violation, that by itself. And there was physical touching, because my client said that his genitals were touched inappropriately. For goodness sakes, I mean, that's touching. And then, and if you look at the event that preceded that, it seems to suggest pretext, because the officer had him do this full body search because he went into his pocket to get his insurance and registration. Could you imagine going through that? I've never had to go through a full body search outside of my car because I reached into my pocket. And he was not able to identify any risk or any or reasonable, identifiable reason why that search had to occur. Also, I think it's important. It seems as if we're forgetting that in JKJ, which this court determined in 2020, full en banc, that if the risk is obvious and there's a predictable harm, then you don't need a pattern. So I'm not just relying on Canton. I'm relying on Seventh Circuit law. It is entirely predictable that if officers do not receive racial profiling training, that incidents like this will occur. Thank you, Your Honor.
You're quite welcome. Mr. Larchick, thanks to you. Mr. Friedman, thanks to you. We'll take the appeal under advisement. We'll move to our second argument of the morning. It comes in appeal number 243115, the United States versus Philip Mayfield. Good morning.
John Metter for appellant, Mr. Mayfield. May it please the court, counsel. Mr. Mayfield was charged with 2 counts of possession of methamphetamine over 50 grams. It was after conferring with Mr. Mayfield over several months, we decided to take this case to trial because the discovery in this case was lousy. The government had very little evidence that he had actually committed the crime. There were 2 buys. The first buy involved having the undercover or the confidential source wear a microphone and a camera. The camera didn't work. The second buy involved both a camera and a microphone again, and there was just a fleeting shot of Mr. Mayfield, and the confidential source misidentified Mr. Mayfield as the passenger in the car. So 2 weeks prior to the trial, the government showed up, and when we were standing there for a pretrial, handed me a subpoena saying, "We've just subpoenaed these documents." I said, "Well, okay, what's going on? You know, what are you doing?" And then we had the pretrial in which we talked about the Facebook subpoena, and I at the time thought, well, if they've got evidence that I really need to see, then I wish I'd had it, so I maybe could have presented it to Mr. Mayfield, and he may have taken a plea offer or something, because I thought they had smoking gun evidence. A week later, we had moved it and kept moving it, and Facebook or Meta had not provided the evidence or the Facebook documents just prior to trial. There was some dispute, some belief that I was going to ask for continuance. I, of course, would have asked for continuance, but I had the documents. I did not have the documents. When push came to shove, we decided just to go to trial because I had the government over a barrel. The evidence was lousy. And I guess I would have had a couple of options at that point, but I had them over a barrel. If you read the statement of facts, they really had very little identification evidence of Mr. Mayfield. It was a lousy case. So here's a couple of problems. The speedy trial argument is not a very good one because I never would have been able to make it. Had I, on day 71, filed a motion for speedy trial, Judge Lawless would have said, well, what are you trying to do? You've hired counsel. You've hired an investigator. What harm do you have here? The point I was trying to make when we had this pretrial hearing was that not only the government didn't attempt to hand me 18,872 documents, they waited until the last moment to ask for them. In a case where identity was on the table from the very beginning, because I had filed a motion to strike count 2 based on grand jury testimony. It was false. I didn't. Unfortunately, you've got to prove that the false grand jury testimony was intentionally proffered to the grand jury and got an indictment based on false information, knowing it was false. But identity was always on the table here. And what was frustrating for me, and I think, I know this speedy trial argument's not going to work, but there needs to be a penalty affixed to granting a motion for continuance when the government hasn't even bothered to look for the evidence.
You're getting into the substance of the Speedy Trial Act now, but you don't dispute that you did not file a motion to dismiss the indictment.
Right. And I just
How do you
don't-
get around our case law that has said if you don't file a motion to dismiss the indictment based on a Speedy Trial Act violation, that you've waived that argument?
The problem with the speedy trial argument all along was that I wasn't really worried. I wasn't contesting the timeliness of the trial. I was more contesting their failure to ask for this discovery later. So let's say I filed a motion on day 71. I'm not in a position to say.
Are you saying you're not making a Speedy Trial Act violation
No,
argument?
Judge, I don't think that's the better argument. I don't think that's the best argument, and I think it's in my brief. I think there's a non-time sensitive error here that I'd really like the court to draw attention to, and that is the failure to exercise any diligence in getting this evidence and then having a late filed motion or oral motion, written motion for continuance when there's been a lack of diligence.
That seems to be a new argument.
Yeah, I didn't see that. I mean, you didn't file a reply brief.
Yeah, Judge, my apologies.
So if you filed a reply brief and you could have clarified the basis of your argument, but I very much took away from the papers. We'll see what if the government has that view. I very much took away that this is a Speedy Trial Act violation.
No, well, I'm looking at my page 24, and I'll just read. And I said, it's difficult to find cases examining the granting of a government motion for continuance to secure documents and the resulting non-time related harm. I was not looking at time-related harm necessarily. I made that argument because I thought, well, you know, it did extend it beyond the time limits. The foundational evidence for a speedy trial violation, things like in the interest of justice and those sorts of predicates, aren't relevant to my particular argument because...
Are you pursuing a violation of the Speedy Trial Act?
No, Judge, I would pursue the second issue.
Okay, so you're waiving any argument that the district court erred in granting the motion for continuance?
No. My argument is that she erred in granting the motion based on giving the government additional time to seek documents.
So I just want to make sure, because I think I asked a double negative there,
Okay.
so sorry. Are you arguing that there was an error based on a Speedy Trial Act violation?
No, Judge, the 3163 argument, I'm not going to rely on.
Okay. Your argument is that the government was not diligent
Correct.
in seeking the documents in a timely manner.
Right, so let's put it this way.
Did you argue that to the district court?
Yes, I did. I said, this is the oral transcript that I provided later.
I mean, I got to tell you, Mr. Meadow, your brief is
My
really
apologies.
confusing on this.
Okay.
I'm reading directly from page 22. I've read the whole entire brief, and in your conclusion, you say, therefore, the defendant was denied a speedy trial, and this court should dismiss the indictment with prejudice, C-3163B.
Right.
You framed the argument in your brief as a denial of a speedy trial right that was affected as a result of the court granting this continuance. And when the government responded accordingly, and you didn't file a reply brief saying, hold on, everybody is misunderstanding what I'm arguing, I don't know that you can save it in the courtroom here.
Well, Judge, I mean, it was in my brief, and so, I mean, if you look past page 22, I continue to make the arguments and offer a test that I think is applicable, so.
The court should find in your conclusion that the continuance violated the defendant's right to a speedy trial. Alternatively, the continuous prejudiced the defendant. I mean, maybe it's there, but it's all wrapped up in the Speedy Trial Act. I'm just reading from your brief.
Well, I guess I'll read from the latter part of my brief, because that's where I'm trying to make this argument that there has to be a penalty affixed to granting a continuance when they haven't even sought evidence. It's one thing to hand me 18,872 documents 2 weeks prior to trial, and I might have a chance to go through them. Probably
So what's
not.
the source of the legal violation? Is it the due process clause of the U.S. Constitution? Is it the speedy trial right in the Constitution? What's the source of the violation?
Yeah, it's not the speedy trial right because it's not related to just getting a speedy trial. The timeliness, it's the error affixed to granting a late filed subpoena, granting the late.
And what did that violate? I understand what you're saying now in the courtroom. What did that violate?
Well, I mean, I was trying to set up a rule. The only decent cases I could find are cases in which they failed, district judges failed to grant continuances to get additional evidence. In this case, if she just said no to the government, this is my scenario, if she said no, we're going to trial on that date, February 12th, what would it look like?
Are you making any argument now in the courtroom that any constitutional right of the defendant was violated?
I am. Well, if it would have to be embedded in this lack of diligence on part of the government, Judge. But no, I'm happy with the test I set out here. I mean, I could have couched it in terms of due process and Fifth Amendment, but I didn't because I wanted to.
Is this just a discovery violation you're arguing then, without being grounded in the Constitution?
Yeah, I think I don't have to get into the Fifth Amendment or something like that in order to complain about the late granting of a continuance when there was no diligence or lack of diligence, when they had due notice that this is always an issue.
You're not contesting the materiality of what they were seeking from that, are you?
Well,
You're
at the
just
point I
saying it
made
was
the
too
objection,
late.
I didn't know what was in it. That was the problem.
But on your appeal, you're not contesting the materiality of the documents or photographs, images.
Yeah, that would undermine my argument because it was so material. I think it's exactly what tipped the trial.
All right, why don't we hear from the government? We'll give you a
Thank you,
minute on
Judge.
rebuttal. Okay. Ms. Boyle, good morning.
Good morning, Your Honors. May it please the Court, Counsel, my name is Catherine Boyle on behalf of the United States. Your Honors, the government here also took defense counsel's argument to be based on a Speedy Trial Act violation. I think potentially part of the confusion might be arising from a misconception of what sort of prejudice to a defendant when you look at the abuse of discretion and whether actual prejudice occurred. I think in the defendant's brief they were conceptualizing prejudice as whether it was something that would assist in his conviction at trial, whether the evidence was inculpatory. And I think that might be going to some of what Mr. Metter was saying up here. And that's actually not the standard, and I think that has created some general confusion in the briefing as well.
That's the prejudice attached to the Speedy Trial Act.
Exactly, whether it hampers the defendant's ability to present his defense at trial.
Yeah. But it sounds like that's, in fact, he said that's not what he's arguing.
That was what I initially understood defense counsel to be arguing. Here we view this appeal as solely involving the defendant as only having raised whether the district court abused its discretion in granting the government's motion to continue and whether actual prejudice resulted. We think you don't even get there though, because this is a situation where defense counsel didn't file a motion to dismiss the indictment on speedy trial grounds, and under 3162A2 that is required, otherwise you're waiving a Speedy Trial Act claim. So we think the appeal stops right there. But even if one were to go on and examine the discretionary portion of this is a case where the district court clearly acted well within its discretion in granting the government's motion for a continuance. The record shows in this case that the government found out on January 23rd, 2024, that there was this Facebook profile. Wasn't under the defendant's legal name, it was under the name Philly the Great, and by the next day, the government had obtained a search warrant and had delivered that to Meta. At the next hearing on January 26, 2024, the court was aware of the search warrant because I think the district judge had actually handled it, and defense counsel was aware of it within a couple of days as well. And notably at this time, defense counsel had also been contemplating a continuance. The defense attorney noted that at the January 26 hearing. In the government's motion to continue, they noted defense counsel had emailed the court on January 31st suggesting there was a possibility of a continuance. At the February 2nd hearing, when we're still awaiting these documents from Meta, the defense counsel is again still contemplating a continuance, and it's actually not until February 6, 2024, when defense counsel sort of gleans, I have a potential Speedy Trial Act issue I might be able to raise here, along with some associated issues, that he suggests, I don't think I do want a continuance. But at that point, the government has made an oral motion to continue based on the need to get these Meta records. And these Meta records, I want to point out also, are really foundational. The government had seen a number of the screenshots it would have wanted for trial in January on the Philly the Great Facebook profile, but in order to get those admitted, the government needed to authenticate and lay foundation. So when the defense counsel says this is, a dump of 18,000 pages of records, it is 18,000 pages, but really the purpose of this is authentication and to show that this is Mr. Mayfield's Facebook profile. It has his social security number associated with it, things like that. So based on the court's discussion on the record at the February 6th hearing, the court acknowledges that this is evidence that's material to the government's case. The government has the burden of proving identity, and the government has exhibited due diligence. It wasn't even aware of this Facebook profile until the day before it got the search warrant, and shortly thereafter raised this to defense counsel as well. Government followed up with a written motion. The district court made the finding that the ends of justice outweighed the defendant and the public's interest in a speedy trial. That was a very reasonable finding on this record, given that the government had exhibited due diligence and that this was material to the government's case and necessary for effective preparation for trial. If your honors have no questions, I'll rest on the arguments in our brief and request that the court affirm.
Hearing none, thank you, Ms. Boyle.
Thank you.
Mr. Metter?
Thank you, Your Honor. Just briefly, it is true the factors that I'm not really concerned about don't involve the timeliness of the trial. It has to do with the lack of diligence. And there's a diligence argument, I guess, a part of the speedy trial argument or statute, but there needs to be, or there has to be a penalty affixed to the granting of a continuance when they've made absolutely no efforts to get this meta information previously. I think there's a standalone challenge that at that moment, if you were to just simply envision that Judge Lawless had said no, we're going to trial, what would it have looked like? So that's my argument. Thank you very much.
You're quite welcome. With thanks to both parties, we'll take the appeal under advisement. Mr. Madich, special thanks to you. You took the case on appointment, correct? Yep, we appreciate it very much, your service to the court and to Mr. Mayfield. Our third argument of the day comes in appeal number 242241, the United States versus Tyrone Johnson. Mr. Mitchell, nice to see you.
Good morning, Your Honor. May it please the court, Gregory Mitchell on behalf of Mr. Tyrone Johnson. Judge, this case really comes down to, from the facts as you laid out, the only potential defense that the defendant Tyrone Johnson had in this case. That's clearly laid out, and it's not really contested by the government, that this was a case that could easily be wedged into the federal statute of child pornography, but whether or not, in essence, was this a federal case that was intended by the statute and the case law. What I simply argued at trial, and I took a very careful look at whether or not I could even file a motion to dismiss on constitutional grounds, and the law was not in support of that. So the counter theory that I could possibly argue, and the only theory he really had at case, was whether or not this should be a federal case at all, given the understanding of the statute with the intent that's required, the international or the interstate commerce connectedness of it. That was really the only argument that he had, and there was clear evidence.
You aren't challenging the pattern instructions that were given, are you? You're
No.
saying some additional instructions should have been given.
Yes, Your Honor.
So you're fine with the patterns that were given?
Yes, Judge. There was no basis to contest them because essentially they were designed with the intent of the statute, which involved the facts.
And is your argument that the law requires your client's personal actions to involve interstate commerce, or that the government didn't prove the interstate commerce element through the movement of the video or the device that was used?
My argument at trial was just a little bit different, and I think Judge Simon picked up on it right away. My argument was not whether or not this particular individual and the evidence, because the phone was from Vietnam. I mean, that's it. But there wasn't any case law that simply said that was enough to affect commerce. We both argued that, we understood that if that was the only connection to interstate commerce, that would likely not have been enough, because there was not enough case law to support that the very fact that every single cell phone in the United States is not made in the United States, that somehow, if any offense involves a cell phone, that would be sufficient as a nexus to interstate commerce.
Doesn't U.S. versus Foley support that?
It argued essentially that wasn't alone. It was one of several factors, and that's the issue that I indicated, Judge, is that when you look at essentially the intent of the statute, the child pornography statute in this case talks about development of child pornography intended to be used or distributed beyond. And there's cases that we were looking at that when the courts looked at what we considered non-distribution or economically motivated pornography that was sort of incest or some other type of personal kind of, that the statute really wasn't designed to try to punish that behavior. Clearly it could, but that was not what the statute was intended for. So my purpose in asking for these additional instructions was to allow the jury to understand that distinction. And clearly the district court said, I don't have to do that. The law, that I could, but I don't have to. And my argument is Edwards, pretty much from this court, which has not been argued against, pretty much says is that the defendant is entitled to his theory of defense if the instructions that they are offering are consistent with the law, and in fact, it's a theory that's not being presented from the government's instructions. And so what I was simply trying to argue was that my instructions characterize the offense, that the character of this offense was different than the way the offenses were being characterized by the government. And essentially, I was asking for the jury to be allowed to consider the character. And in this case, Judge Simon, in fact, sort of split the baby. He basically said, I'm not going to give you your instructions, but I'm going to let you argue it. And he did, and I argued it in closing, as pointed out in the government's brief. But I think that not allowing those possession instructions in particular, and with respect to Mr. Tyrone Johnson's intent with respect to having the phone when he crossed state lines, not to produce or distribute pornography, not to sell it anyway, but just that it's on his phone. And I think that the critical piece of evidence that was developed by the government that I cited was that when it was initially examined by their expert, that phone, the conclusion was this was not a case that indicated child pornography. That's what the expert initially decided when they reviewed the phone. It was later, once it was evaluated in terms of the thumbnails and some other things, that it could be, because there's something on the phone that indicates that it was there before it was, and so therefore, even though it was never distributed, it was never intended to be distributed by anyone, the very fact that there's remnants of it on the phone, and the phone had actually been carried by Mr. Johnson on his person, as a personal phone usually is, from one state to the other, that additional nexus was enough.
How, accepting your argument, your proposed instruction number 3 asked the court to instruct the jury that in order to prove interstate commerce, they had to find that the defendant knowingly traveled in interstate or foreign commerce and did so for the purpose of distribution of the visual images. How does that support even what you're saying? And the law is crystal clear that the defendant doesn't have to travel in interstate commerce.
This is true, Judge, and again...
That would be counter to the law. That would misrepresent the law about how you establish the interstate commerce.
And I understand with respect to the cases dealing with child pornography distribution. That is correct. When the facts indicate that the government doesn't, when it involves conduct other than the defendant, those cases say the government doesn't have to prove.
Yeah, see, I think the problem with your argument is when you look at the elements of 2251A, which your client was convicted of, producing child pornography, and then you look at instruction 17 as it was given, in particular paragraph 3 of instruction 17, it aligns with the elements of the statute. And that's probably why it's in the pattern instructions, because what it says is that the visual depiction was produced using materials that had been transported in or affecting interstate commerce. And that's the problem that you recognized at the beginning. The cell phone comes, from out of state.
You're absolutely right, Judge, and I recognize that as well. And if that's the end of the game, then there's nothing to argue.
Your proposed instruction 3 would allow the jury to acquit the defendant even if the image that was produced went across state lines, but the defendant didn't. And I think even you standing here would agree that's not the law.
No, it isn't, Judge. And my instructions in reliance on Edwards was really to tailor these additional instructions for the facts of this case. And I wasn't trying to charge or argue against the elements that the government clearly had evidence on from the pattern instructions. I was trying to expand based on my theory and the only theory that the defendant actually had, to allow the jury to consider that. And again, I think Judge Simon understood that that was pretty much all I had, and that was the only basis to which to argue with Edwards. But he was not going to sanction the court to allow the jury through instructions to do that. And I think, Judge, that given the unique facts of this case, they have to admit that the Vietnam issue wasn't enough. It was the actual carrying. And I think that given...
Hold on. Why do they have to admit that, given the way Congress drafted 2251A?
I don't think they...
We'll see what Mr. Whalen says, whether they have to admit that or not. But that seems odd to me, because it seems at direct odds with the text of the statute.
I think what I'm speaking to, Judge, again, is not what the pattern says. I'm looking at the facts in this case. I think that the government knew in this particular case that if that was the only nexus, then my argument would have been stronger. They strengthened it, of course, by arguing the alternative theory. And because of that, I felt the only defense that I possibly could argue was the character. And I understand, but...
Well, let's see what Mr. Whalen says. You reserve some time for rebuttal. We'll give you a minute on rebuttal.
I didn't reserve any time, Judge.
Well, okay. All right. Well, if you want a minute or so after Mr. Whalen goes, you're welcome to have it. If not, you can waive it.
Thank you, Judge.
Okay, you're welcome. Mr. Whalen, good morning.
Good morning, Your Honors. May it please the Court. Nathaniel Whalen here on behalf of the United States of America. The District Court did not err in giving the pattern instructions in this case. It did not err by failing to give the defendant's proposed instructions. Defendant wasn't prevented from presenting his defense, and he was not deprived of a fair trial. I guess let's pick up where we left off, and Judge Scudder, I think you correctly predicted my position. We do not concede the Made in Vietnam wasn't sufficient to satisfy 2251. I guess that's too many negatives. Stated positively, the fact that the phone involved materials that have been transported in interstate commerce fits squarely within this statute. That's what Worley said, what this court said in Worley. It's what the 11th Circuit said in the case that overrules defendant's proposed instruction number 1. The fact that you use a device that has parts that were made from a different state is sufficient to violate 2251.
I mean, it follows from the text of the statute. The only argument available is that the statute's unconstitutional, that it exceeds commerce or foreign commerce power, and that's a hard argument to make under the current law.
It's one that this court's rejected, and it's one defendant explicitly disclaimed when he was asking for these proposed jury instructions. He said, I'm not challenging the constitutionality of the statute, and I understand that. I get he's got a heavy road to hoe if he wants to make that argument. I think the problem with the instructions in this case, though, are that they did kind of implicate the Commerce Clause analysis, which isn't an appropriate consideration for the jury. We don't want the jury considering whether the defendant's conduct presented a substantial effect on interstate commerce, because that's not the question.
And they're legally wrong. I think that's certainly the first three.
That's correct, Your Honor. I think 4 and 5 are a correct statement of the Commerce Clause.
Yes.
1, 2, 3, and 4 are incorrect. I'm sorry, 1, 2, and 3 are legally wrong. I will say 3 is not legally wrong as it relates to 1465, and that's, I think, where the confusion comes in. The court's pattern instructions reference 2251 to look for define interstate, foreign, and commerce. And that's what this court did. That's what Judge Simon did. That's on Defendant's Appendix 11. What this proposed instruction does is go one step further, and it takes the elements from the 1465 offense. And if you look at this proposed instruction consistent next to 1465, they're identical, because this is the correct instruction for 1465.
But that wasn't charged here.
That was not charged here, correct, Your Honor. And so that's legally wrong as applied to this case. And that is the problem with these instructions, ignoring the fact that 4 and 5 are correct statements of the Commerce Clause analysis. That's not a question for the jury. 1, 2, and 3 are legally wrong as applied to the facts of this case. And that's why the court properly declined to give the instructions. As defense notes, though, he was able to make the argument that he wants to make. He was able to quote extensively from his proposed instruction number 4 during closing arguments. And, I will say Mr. Mitchell did what he could with the case that he had. And I don't mean to be disparaging of the instructions. I understand sometimes you're up against really bad evidence and you do what you can. I think this was a valiant effort to maybe try to make an argument that there was no Commerce Clause element here because there was nothing else to do. The defendant is caught on camera sexually assaulting a 9-year-old. The phone is stamped made in Vietnam, and he literally carries it from one state to another. I mean, there's no daylight in the elements there, and that's why he was also not deprived of a fair trial. The evidence of guilt was overwhelming. He was able to present his defense, and there was no error here. Unless this court has any questions, we would ask you to affirm Mr. Johnson's conviction. Thank you.
Mr. Whalen, thanks to you. Mr. Mitchell, anything you want to add?
No, Judge.
Okay. We very much appreciate your advocacy. We know you took this case on appointment, and we appreciate your service very much to your client and to the court. Thank you. The fourth argument of the morning is the United States versus Brett Seagull, appeal number 24-1537. Mr. Shepard.
May it please the court. Good morning, counsel. I am Adam Shepard. I represent Brett Seagull. Our principal contention on appeal is that the district court did not adequately explain its reason for imposing a sentence above the minimum of the guideline range, which was 70 months, and the court imposed a sentence of 76 months under 3553C1, a sentence that is over 24 months. The court is required to point to the reasons why they are imposing a sentence not at the bottom of that range. And although the district court acknowledged the arguments in mitigation and stated that it considered them, there was no indication on the record as to if they were specifically rejected or why they were rejected. For instance, there was not a specific finding that factors in aggravation outweighed the factors in mitigation. And while that may be implied, given that the defense requested a variance from the guidelines, the defendant requested a sentence of 60 months, the mandatory minimum, the defendant himself did not know what arguments were credited in mitigation and which were...
What in our law requires that kind of specificity from the judge? Our law says the court has to consider arguments that are made, but our law doesn't require judges to tell what particular weight they put on any particular argument.
I would, yes, Your Honor, with respect to not a specific requirement to assign a weight to one particular argument, but the authority we're relying on we believe the law is that I'm quoting from U.S. versus Villegas Miranda, cited in our brief 579 F. 3rd 798 801 7th Circuit 2009. Quote, I wrote, the sentencing court, and then quote, must state its reasons for rejecting a defendant's principal arguments if the arguments have merit. We submit that the arguments were meritorious. They've been recognized by several courts of appeals as having merit. The defendant was a first offender. This was his prior arrest. He pled guilty to the lead count in the indictment, which carried the mandatory minimum of 5 years. Understand every defendant isn't eligible for a below guideline sentence, but to go above the bottom of the guideline range, we believe wasn't sufficiently explained.
One of the arguments you make in your brief is that I want to ask you about when you look at like what we've said in cases like Garcia, Segarra, and Brown, is you argue that the district court's inquiry in two different places in the sentencing transcript of whether mitigation evidence and anything else for that matter, was adequately considered is you join issue with the exact way the district court presented the questions. Okay? You know what I'm talking about in your brief?
Yes.
Okay.
Yes.
Have we ever held, and did we hold in Seagull, Garcia, or Brown that the questions have to be asked in some sort of exact formulation of words?
No, Your Honor. The district court did consider them based on the court's recitation. What we don't know from the record is which arguments were persuasive or not.
So you're not, even though in your reply brief you said that on page 2 the question did not track the language. And you said, nor did the court ask whether, and then you quote from Brown. These are arguments you're drawing upon from Garcia, Seagull, and Brown. So are you arguing that there's some kind of magic words formulation?
The language in Garcia Segura was that the court was to address, and I argued in my reply brief that address, and there's a distinction between address and consider. Address, I believe, involves some type of analysis so that the advocating party knows whether they were found persuasive or whether they were credited. Considered, the district court judge acknowledged that he considered them, but the defendant was left unknowing how they were resolved. And we quote the different case law for the
How do you get around the second question the court posed? Do counsel for either side have any legal objection to the sentence I propose or request any further elaboration of my reasons under 3553, both as to the term of imprisonment or supervised release?
Because under Garcia Segura, the time for that inquiry is supposed to be, quote, after imposing sentence, but before advising the defendant of his right to appeal. In this case, the court, on page 37 of the sentencing transcript, posed that question before imposing judgment. The court had said it, quote, do counsel for either side have any legal objection to the sentence I propose or request any further elaboration of my reasons under 3553? And that came before the actual imposition of the judgment.
Counsel, I'm looking at the 3 sentences that immediately precede what you just read, which states it is the judgment of the court that the defendant be committed to the Bureau of Prisons for a total term of 76 months. I understand that he says, I propose, and I perhaps the written judgment was not entered until after the hearing, but I see clearly that he said, I'm going to give 76 months. And is there any objection?
But then on line 25 of page 37, that's when the actual imposition of the order occurred. I realize, Your Honor, that it maybe it's a distinction without a difference, but that is the law from the circuit. And I suppose the rationale is it gives the lawyer one final opportunity before that window closes, before judgment is formally pronounced and imposed, to raise any procedural objections. So I don't think there was a waiver in this case because the judgment had not even been orally imposed yet.
Mr. Shepard, you asked to reserve 3 minutes
Yes.
for rebuttal. You want to save the remainder of your time?
Yes, may it please the court. Thank you.
Okay. We'll hear from the government. Ms. Shmesa.
May it please the court. Branka Simasha for the United States. The defendant has waived his Cunningham procedural error arguments, but even if he didn't, the district court did not commit procedural error. The defendant's procedural error argument is waived pursuant to Garcia-Segura, which counsels district courts to inquire of defendants during the time of sentencing whether the court had considered their arguments in mitigation. And the court did exactly that. After discussing the arguments in mitigation, the court asked the defendants, "Have I considered your arguments in mitigation?" And the defendant answered, "Yes." And then, after imposing the sentence and having a further discussion of aggravation and 3553A factors, the court again asked both of the parties, as Your Honor pointed out, does anybody have an objection to the sentence imposed or would like further elaboration of any part of the sentence?
How do you respond to Mr. Shepard's argument that that second inquiry was after the court said the sentence it intended to impose, but it didn't formally impose it until after then?
Your Honor, the case law does not require the court to ask that question after any particular part of the sentencing hearing. In fact, in the Garcia-Segura line of cases, the court has stated that even posing that question after considering the arguments in mitigation, but before imposing the sentence, would be acceptable to trigger waiver. And waiver was triggered in this case. Additionally, Your Honor, in terms of the appropriate words to use, the case law does not require district courts to ask the question in some particular way. There are cases in the Garcia-Segura line of cases where district courts have asked, does anybody have an objection, and would the defendant like further elaboration, which is exactly what Judge Blakey asked in the second time he asked that question during the sentencing hearing. So the court was spot on what is required under the Garcia-Segura line of cases. Furthermore, even if the argument is not waived, the district court did not commit procedural error. The district court, based on the totality of the record, reviewed submissions by the parties, heard arguments by the defendant and the government, and went through all of the defendant's arguments in mitigation, crediting them, talking about mental health treatment, good conduct on pretrial release, family support. The district court even talked about the defendant's policy arguments, opposing the sentencing guidelines, and then went through the aggravation in the case. The district court thoroughly explained the sentence it imposed, the within guideline sentence, and highlighted the horrific nature of the offense in doing that. And then finally, I'll just note that within guideline sentence is presumed to be reasonable and is virtually unassailable, and how the court weighs those factors goes to the analysis of whether or not the sentence was substantively reasonable, not whether there was procedural error. So to the defendant's point about not knowing how the court weighed those factors or what the ultimate resolution of those factors was, that's not even a part of the procedural error analysis. So unless the court has further questions, I'll end by asking you to affirm the sentence.
Okay, hearing none, thank you.
Thank you.
Mr. Shepard, you're welcome to use the remainder of your time if you wish.
Thank you, Your Honor. Your Honor, respectfully, most of the government's cases also involved a judge's inquiry about whether it considered factors in mitigation after the imposition of the judgment, and I have not seen any case law that rejects the Garcia-Segura language about the time for that inquiry being after imposing sentence. I should say most of the government's cases involved after imposing the sentence, such as in the Brown case. The defendant's psychosexual evaluation, I'm turning to substantive reasonableness for a moment, put him at a low risk of recidivism. He was ineligible for a first offender adjustment under 4C because it seemingly doesn't apply to receipt of child pornography cases. So that was an argument that maybe a court can vary based on the fact that the guidelines don't account. Based on the totality of the record, including his early cooperation when the FBI came to see him initially. We'd ask the court for the relief of remand and a new sentencing hearing. Thank you.
Mr. Shepard, thanks to you. Mr. Mesa, Mr. Kerwin. Thanks to you. We'll take the appeal under advisement. Mr. Shepard, I see here that you took the case on appointment.
Yes, Your Honor.
We very much appreciate you doing so, your service to your client, Mr. Seagull, and to the court. So thank you.
Thank you.
Come to the fifth argument of the morning in appeal number 242469, Brian Singer versus the City of Chicago. Morning, Ms. Gilbert.
Good morning, Your Honors. Your Honor, I brought this appeal because the district court erred in using the Illinois Single Refiling Rule 735 ILCS 5/13-217 in dismissing plaintiff's complaint as untimely. As Your Honors might know, the state refiling rule provides the action is voluntarily dismissed by the plaintiff or the action is dismissed for want of prosecution. The plaintiff, his or her heirs, may commence a new action within 1 year or within the remaining filing period of limitation. What happened here is the pro se plaintiff filed 3 complaints, and the city came up with an argument that their second complaint, what they were calling Singer 2, was related to the first complaint and constituted an inappropriate second refiling. And they're saying you can't have 2 bites of the apple. Well, here, Singer 2, and that's 18 CB 4818, is like apples and oranges. Singer 2, the plaintiff, the pro se plaintiff, sued his neighbors, the condo association, and a law firm representing the condo association for a variety of things. He said that since 2012 up until the present time, they had harassed and discriminated against him based on his Judaism, disability, and committed ongoing violations of insurance fraud and allowing an illegal roof deck to be erected. Judge, this is night and day, or Your Honors, this is night and day from the original pro se complaint that was 1 page that Brian Singer filed against one police officer, Michael Cooney, and the Chicago Police Department.
What about paragraph 7 of Singer 2 that refers to the city of Chicago and the police officers and specifically notes the plaintiff is reserving his right to amend the complaint to add the city as well as the police officers who were involved in the events of October of 2015, which are the exact same events that were subject to Singer 1.
I acknowledge that, Your Honor, and what he was attempting to do is reserve his right for a future filing at a future date, which was exactly what Singer 3 was. So
can I ask you while we're on the Singer 2 complaint for just a moment? Can you look at 12, paragraph 12? I think, to my mind, the only way to explain 12A, you see it there?
I don't, Your Honor. I actually.
I can tell you what it is.
Okay.
12 is where he lists his injuries. Paragraph 12. And he says in 12A, permanent injury to lumbar, cervical, left shoulder, hospital bills, etc. Okay, remember that?
Yes, I do. Your Honor,
the only way to explain that, in my view, is I don't think his contention in Singer 2 is somehow that the named defendants, personally injured him, physically injured him, and caused him to incur $15,000 of medical bills. I think that has to be a reference to the physical injuries that are coming out of the altercation with the police department. I think it has to be, and the only reason I say that is because it links to 1 and then it links to 3 that way. So he had to have believed that the named defendants, who you recounted for us, somehow caused those injuries such that they're on the hook to compensate him for them? Because I don't know why else he would have included it.
Well, first of all, these pro se complaints need to be liberally construed in favor of the plaintiff. And these are form complaints, right? This is some sort of form that's put out by the United States District Court here in the Northern District.
I get all that, though. Can you just focus on what I'm asking you? What
I don't
I'm asking
think-
you is 12A a reference to injuries that you believe he incurred from anybody other than the police department?
No, I think I would concede that 12A appears to be his physical injuries from the excessive use of force by
Right.
Michael Cooney. However, I don't think that one line should be used against him in a pro se complaint when it's clear that the named defendants in this case, the first complaint in state court and the third complaint in this federal district court, were Michael Cooney, and that was clear as day.
But why doesn't that go, the paragraph that Judge Scudder just identified seems to go consistent with what he said in paragraph 7, where he's claiming that the named defendants in Singer 2 helped cause their actions and misfeasance, including false police reports, helped incite the CPT officers to engage in this conduct. It seems when you put those two together, the injuries caused by the police officers and the allegation that the actions of the named plaintiff helped incite, cause, whatever verb you want to use, the police officers here to engage in the conduct at issue, that has alleged the same thing.
Your Honor, I think he simply reserves the right to bring this at a different time, which is exactly what Singer 3 is. And I think that...
Then why seek damages for that conduct?
Well, he's seeking damages for a myriad of injuries, but he lists those damages. However, it's clear that the dates are different, the named defendants are different. The nature of the claim, Singer 2 is so detailed, he attaches an addendum that says exactly how the condo association, the neighbors, and the law firm wronged him, and it attaches very, very detailed description of what they did. Rather, the complaint at law is a one-page piece of paper filed in state court, and then the Singer 3 is the form complaint that alleges conduct just by Michael Cooney and the Chicago Police Department. I think under the liberal pleading standards, and additionally to the saving clause, 735 ILCS 5/13-2.7, both of those are supposed to be liberally construed to give the plaintiff a cause of action on the merits of his claim. I'm at my reserved time, so thank you.
Yeah, you want to save the rest of your time? No problem. Okay, very well. Mr. Smith, good morning.
May it please the court. Illinois law allows a plaintiff who has voluntarily dismissed his complaint one and only one opportunity to refile it. The narrow question at issue in this appeal is whether, in dismissing Mr. Singer's complaint, the district court correctly applied that single refiling rule. And the Illinois Supreme Court's controlling decision in First Midwest Bank v. Cobo makes quite clear that the district court's application was correct. So I'd like to begin with Cobo because I think there's a really important point embedded in the analysis there, which is that it held that the test for the refiling rule borrows just one of the three elements of res judicata. Not final judgment on the merits, not identity of the parties, only identity of the cause of action. So I believe opposing counsel has suggested that changing the defendants in Singer 2 somehow rendered it a different case, a different cause of action for purposes of the refiling rule. But Cobo could have also borrowed the identity of the parties element of res judicata, but it did not. All that's required is identity of the cause of action, which in turn means the operative facts have to be the same. And as this court has suggested, at least in relevant part, Singer 2 clearly did contain the same operative facts as Singer 1. And just to briefly reiterate, I think there's three important elements of Singer 2 to emphasize. The first is the contention that the condominium association defendants made false police reports, which resulted in the arrest for an alleged kidnapping. So that's the connection between those defendants and then the arrest at issue in Singer 1. It goes on to describe the conduct of the police officers, even if they weren't named there, including that they allegedly knocked out Mr. Singer and that he awoke in a hospital after being released from custody. And finally, it has that damages request related to the permanent injury to the shoulder / cervical / lumbar, I think is the specific wording there. And as you pointed out, Judge Scudder, that could only relate to the excessive force because, of course, there are other claims raised in Singer 2.
So his mistake here, if he made one, is he just simply omitted the defendants. He admitted the police officer defendants, the city, that way. And as Ms. Gilbert is pointing out, that has to be because he's not trained as a lawyer. So he comes in here with the condominium association folks and the neighbors, principally on a discrimination theory. Why shouldn't the latitude around pro se pleading save this? Because the third complaint is filed within the year.
That's correct. I would make 2 points there. One, I think his litigation strategy in Singer 2 actually rebuts that it was a mistake because he has admitted in his own briefing in this case that he actually retained counsel in Singer 2 after he initially filed it. And this is on docket 152 at page 3. It's one of his filings in the district court. And that counsel in that case actually began to subpoena the city, quote unquote, aggressively to identify the identities of the police officers involved. So he was pro se initially, but he later retained counsel, and counsel was taking steps towards actually adding those defendants as he reserved the right to.
Was counsel retained before or after he filed Singer 2?
It was after. But I think that point rebuts any contention that it was just merely a mistake. He clearly was taking affirmative steps to add those defendants before he decided to voluntarily dismiss it. But I would also add that this seems to be a slight misapplication of the liberal construction rule that applies when a court is trying to ascertain whether the factual allegations of a pro se litigant's complaint can be read to state a cause of action. But that's not exactly what we're dealing with here. Here we're dealing with a clear procedural rule, and whether he was pro se or not, he's still bound by the rule. Illinois courts have held that. This court has held that. And, at bottom, he had just the one opportunity to refile Singer 1. And whether he was pro se or not, he brought a complaint with those key operative facts about the arrest and the alleged excessive force used. And that's really the end of the analysis. I'd also like to raise a related point that counsel suggests that the single refiling rule has to be liberally construed in favor of hearing complaints. I would point out that their contention here is not actually a liberal construction of the rule, because the single refiling rule often provides a benefit to plaintiffs, allowing that extra opportunity even for the 1 year outside of the statutory limitations period. Now, they're arguing for a construction where you don't get that chance if you've named different defendants or a broader course of conduct. So it's actually a pretty limited view of the rule. We just happen to be in this sort of awkward case where Mr. Singer is arguing both for and against application of the refiling rule. And I think the only other point I would like to emphasize is that counsel has suggested that there is a broader course of conduct at issue in Singer 2. There's, of course, the insurance claims and the discrimination claims. But the fact that there's those unrelated allegations does not bar application of the single refiling rule because the operative facts are there in part. And for that, in our brief, we cite the last Corp v. Ugent case. That's an Illinois appellate court decision, but it was actually favorably cited in Cobo. And they have not presented any Illinois authority to the contrary. So just to briefly note the facts of that case, the contentions are pretty different, but the procedural posture is actually quite similar. There, as here, there were 3 filings at issue. All of the filings set forth a tortious interference with contract or with business claim. But the second case had a much broader course of conduct alleged. It also had federal antitrust claims and claims based on RICO and a supposed murder for hire plot. So clearly the second of the 3 complaints did have the relevant claim, but it also had much broader facts and contentions raised. But that in the last corp did not bar application of the single refiling rule, and the third complaint there turned out to be a successive refiling, as it is here. All that matters is that Mr. Singer had the one opportunity to refile, and he used it when he brought the Singer 2 case containing the same operative facts as Singer 1, which is the alleged false arrest for the supposed kidnapping and the alleged excessive force that followed when he was in custody. So that ends the analysis. So if there are no further questions, I will relinquish the remainder of my time and just respectfully request that this court affirm the judgment of the district court. Thank you.
Very well. Thank you, Mr. Smith. Ms. Gilbert, you have some time remaining. You're welcome to use it.
Thank you. The case cited by the city actually helps us. The Covo, in that case, the court said this test treats separate claims as the same cause of action if they arise from a single group of operative facts. The court should approach this inquiry pragmatically, giving weight to such considerations as whether the facts are related in time, space, or origin or motivation, whether they form a convenient trial unit, and whether their treatment as a unit conforms to the parties' expectations or business understanding or usage. Your Honors, here, Singer 2 has a myriad of allegations ranging from false insurance claims to the rest was for criminal trespass to property, and he puts that out in Singer 2, how he suffers from the disability of narcolepsy, where he can't stay up, and he was sleeping in the hallway somehow, and he was arrested and charged with criminal trespass. Different defendants, different years, different allegations, completely different allegations, and because the pro se plaintiff mistakenly reserved his right to refile, and he's talking about refile from his state court action, Singer 3, that should not be held against him. In this interpretation of the Illinois Savings Clause, obviously you can't speculate about how the clause should be used. It is how it should be applied here, and how it should be applied here is the Singer 3 was the only other refiling. It was within 1 year of the state court complaint. The judge got it wrong in the district court, and I would say you need to reverse that decision and give him a chance on the merits. Thank you.
Okay, Ms. Gilbert, thanks to you. Again, Mr. Smith, thanks to you and your colleague. We'll take the appeal under advisement. Our 6th argument of the morning is in appeal number 242841, Dalziel versus Mangrret.
Good morning, Your Honors. May it please the court. I'm Trevor Barrett, and I represent the plaintiff, appellant, Dalziel Inc. in this matter. This appeal concerns a rather, I'd say, simple inquiry, which is, did the district court abuse its discretion in awarding a default judgment of $1,000 in statutory damages as to defendant Mangrret, a defaulting foreign Amazon marketplace seller, that the district court found to be a willful infringer of Dalziel's copyrights. And this award being granted despite Dalziel's prior election to recover disgorgeable profits and not statutory damages.
Why didn't you put in a sworn declaration or an affidavit with the Amazon documents to back up your theory of damages? Because I saw an unsworn declaration. I didn't see anything from Amazon confirming the figures cited in that unsworn declaration. So what was the judge supposed to base a profit award on?
Well, Your Honor, we did submit a declaration from counsel attesting to raw data that was provided in business records.
But it was unsworn, correct?
I believe it should have been sworn, and if the language was insufficient, then plaintiff would obviously request opportunity to cure that defect. However, given the lacking analysis that was provided by the district court, we just didn't know why there was a rejection of the sought disgorgeable profits as opposed to statutory damages. There was just a cursory 6-line explanation in which Judge Seeger found indeed that
Does the judge have the authority if you request disgorgeable profits, but you haven't proven them? Does the judge have the authority to instead award statutory damages, or do you have to ask for that?
No, Your Honor. In fact, as provided in the briefing, once an election is made prior to the final judgment being rendered, then essentially the plaintiff stuck with that decision.
So if you hadn't, to pick up on what Judge Maldonado asked you, if you did not submit a proper declaration supporting your damages, the court could have given you 0 damages.
That's correct, Your Honor. Yes.
What I don't understand about that is why in your brief do you argue in the alternative at the end of your brief? You argue, in other words, that if actual damages are not available, then there should have been, an award of higher damages to account for the willful infringement.
Well, Your Honor, simply stated that's to cover all bases. It was an even-if argument, arguendo, but we believe that the law is clear and the statute is clear that once an election is made, that's the form of damages that the plaintiff is entitled to seek. And to the extent that there was lacking evidence to prove up those particular damages, then Dullskill would certainly seek to provide or to submit an amended motion for default judgment. And my understanding of the law in that area is that such amendments are liberally granted, obviously, because the defaulting defendant...
So hold on, I want to make sure of this. You say in a couple different places in your brief, after you make your primary argument's clear to me, okay? You say that if statutory damages, statutory, not actual, if statutory damages were properly awardable on the default here, the district court should have awarded heightened. But you're saying the district court had no legal authority to award statutory damages because the plaintiff opted for actual. So what's the point of the alternative argument?
Again, Your Honor, it was just an even-if argument. We do.
Well, no, I understand the way it's formally presented, but there's no. You're asking in the alternative for something that's not even lawfully available. That's your understanding of copyright law, that once a plaintiff makes a choice at that fork in the road, actual or statutory, you're stuck with actual.
That's correct, Your Honor. The cases that were cited, there's nothing explicitly on point stating that once disgorgeable profits are elected, that statutory damages could not somehow be in the realm of what the court could award. The reverse, there are cases stating the reverse, that once statutory damages are elected, that everything concerning disgorgeable profits are essentially mooted. So just to be careful and cognizant of that fact in case there was movement within the law.
So is that another way of saying, in response to the earlier colloquy, if the district court determined that you failed to make a sufficient evidentiary showing of the actual damages because declaration wasn't sworn, you didn't submit anything that was authenticated from Amazon, anything at all that way, then the district court has no legal authority to award statutory damages. The actual damages would be 0 on a failure of proof.
Essentially, yes, Your Honor, but again, Dullskill would request an opportunity to amend to cure any defects in the actual underlying evidence supporting disgorgeable profits.
Okay.
And I would just further like to direct this court to the recent decision from this court, the Dyson Technology Limited v. David Seven Store et al. Case that just was decided a few months ago, case number 23-2948. and it's very, very highly analogous to this case. And in that case, this court found that the very same district court that awarded $1,000 in statutory damages to dolls killed, in this case, abused its discretion by awarding $1,000 in statutory damages to the plaintiff in Dyson Technology in the face of Dyson Technology's prior election to recover profits. And although Dyson Technology is based on the Lanham Act and this is based on the Copyright Act, the damages provisions of both 15 U.S.C. Section 1117 and 17 U.S.C. Section 504 are for all intents and purposes the same. And they stand for two essential propositions. The first being the right of election of which form of damages to recover belongs to the claimant and not the court. And the second being that to establish recoverable, disgorgeable profits, a claimant need only present proof of the infringer's total revenues, and that's it. The burden to reduce from that figure lies with the infringer, and this court said on that point that it must be presumed that the infringing defendant's sales, that is, revenue, and profits are the same thing until the defendant proves otherwise. And also the court noted that the district court provided a lackluster set of findings and analysis to support the fact that total revenues should not be awarded as a measure of disgorgeable profits. And
Have you had any contact with the defendant in this case? I know you settled with the other defendant.
Other than providing notice, no, Your Honor, there has been no contact.
No attempt to settle with this defendant?
From the onset of this case, we never received a response back from the many attempts at noticing all of the proceedings.
Okay, anything further, Mr. Barrett?
Nothing further. Thank you very much.
Okay, you're quite welcome. Thanks to you. We'll take your appeal under advisement. We come now to the seventh argument of the morning in two appeals, 24, 2560 and 2561, the United States versus Arthur Reynolds. Mr. Peebles, good morning.
Good morning, Your Honor. May it please the court and members of the panel, counsel. Your Honor, Arthur Reynolds is sentenced to 90 months on possession of cocaine and possession of a firearm. The guideline sentence in that particular charge was 60 to 71 months. Now, Mr. Reynolds has had an extensive criminal history, starting when he was a juvenile, up until now when he's 43 years old, and he was sentenced when he was 42. In this sentencing, I would...
Mr. Peebles, can I just interrupt you for a second, please?
Yes.
Because I want to make sure I'm clear on what you're arguing.
Yes.
There were two aspects to the sentencing here: the underlying crime and then a supervised release violation. And you have filed two appeals. Are you on appeal challenging the 57-month sentence for supervised release, or are you just challenging the 90-month sentence on the substantive crime?
Yes, I believe I'm just going to stick with the 90 months. I think that the 57
Okay, so you,
months...
just to be clear,
Yes.
are you challenging on appeal the 57 months imposed for the violation of the supervised release?
No,
Okay, so
No.
just the 90 months.
just the 90 months.
And would you clarify?
Can I pause you? Are you sure about that? The 57 months runs consecutive to the 90. Recognize you have a constitutional obligation to your client.
That's true, Your Honor. I shouldn't
You
waive
sure
it,
you want to withdraw
but
that?
I'll withdraw that. The reason I think I have less of a chance of
Right. So
reversing
the merits may be weaker.
Yes.
Okay. But the argument is, I don't want to. Is the argument on the table or off the table?
I'll keep it on the table.
And what
Your
is
Honor.
the argument then as to the 57 months? Because your brief seemed to focus on the 90 months being a procedural error, I think. I wasn't clear I didn't think you were arguing or challenging the supervised release sentence.
The only thing about the supervised release sentence, because it is consecutive, I think if you take the 90 months plus the 57 months, that's excessive. I think that it is within the guidelines. I think the 57 months was at the high end of the guideline for that revocation of his supervision. But when you combine both the 90 months and the 57 months, he's got 147 months of a sentence. Certainly.
So is it's substantively unreasonable? Because you're not challenging the guideline calculation for the 57 months.
I would argue that it is unreasonable when combined with the 90 months. I think that during the argument and sentencing, the government had referred in a sentencing memorandum to crimes that were alleged to have been committed by Mr. Reynolds when he was a juvenile. And I think that you look at that plus his other activities, there was a passage of time which the guidelines take into consideration in this. But I believe that without that passage of time, Mr. Reynolds could have been facing a career criminal sentencing, which would have been substantially more. And I believe that because of the passage of time, and I believe the argument at the sentencing by the government was that it was merely the passage of time, that Mr. Reynolds was not out being a productive citizen. But I would argue that the guidelines take that into consideration. Passage of time, when he was in the Department or the Bureau of Prisons, he was supposedly there to be rehabilitated. So that is quality time for an inmate in the Bureau of Prisons. And to say otherwise would be ludicrous, really, because that was one of the purposes for his sentencing. I think that there are two prongs involved in sentencing an individual: punishment on one side and rehabilitation on the other. And if he's spending time in the Bureau of Prisons, it goes without saying that he is receiving some rehabilitation during that time. So I would argue that when Judge Dugan sentenced my client to 90 months, which is 19 months above the high end of the guideline, I think that was an abuse of discretion, and I've asked the court to consider reversing and remanding this sentence, that taking into consideration alleged crimes or crimes that occurred when an individual was a juvenile, and taking that into consideration in going up above a guideline sentence is unfair and abusive. Oftentimes a juvenile, juvenile adjudications are sealed for that purpose. They can be looked at and opened if there are future crimes committed, but Mr. Reynolds was a 16-year-old child, and those crimes were taken into consideration when this sentence was imposed. And I think for that reason it was an abuse of discretion, and I'd ask the court to consider reversing and remanding for that reason. Mr. Reynolds grew up in a difficult area. He was living in the projects in East St. Louis, Illinois. It's a tough spot. He made some bad decisions, of course, but he did emerge from the Bureau of Prisons, and he was gainfully employed, so there was some rehabilitation that occurred while he was in custody. Now, unfortunately, he did take responsibility for actions that occurred. Throughout this proceeding, Mr. Reynolds was cooperative with the government and with the investigators. He took responsibility. He pled guilty. He did not force the government to go through a trial in a case where the evidence was very strong against him. And for those reasons, I would ask the court to reverse and remand this.
Okay, you got a little time on rebuttal. Before you sit down,
Yes, sir.
Mr. Peebles, I want to extend a friendly suggestion,
Yes, sir.
and I hope you take it this way.
Yes, sir.
In your brief, the appendix to your brief, under our rules, you have to attach all the rulings that you're appealing from. You follow me on that?
Yes.
And we actually require lawyers to certify that they've done that. Your appendix here doesn't include that, does not include the sentencing transcript, the underlying judgment, and instead includes something that we often do not see copied and put on a public docket, and that is the PSR. So my friendly suggestion is next time around, take a look at your appendix and make sure it includes what it should include and omits what it shouldn't include.
Absolutely. Thank you, Your Honor.
Okay, you're welcome. We'll hear from the government.
Thank you, Your Honor. May it please the court, Daniel Caraway on behalf of the United States. Your Honor, after an extensive revocation and sentencing hearing, the judge sentenced Mr. Reynolds to an aggregate 147-month sentence, which constituted 90 months, which was a slight variance over the guideline range for the new indictment, as well as a within policy statement sentence on the supervised release. While defendant has made some passing challenges to his sentence in his brief and during argument today, I'll start where our brief started, and that's with the waiver argument. Your Honor, I think the perfunctory and underdeveloped arguments from the brief, which were not supported by pertinent authority, as this court has held, are required under Berkowitz, failed to really identify whether or not appellant was making a procedural challenge to the sentence, a substantive reasonableness to the challenge to the sentence. However, as this court did in Berkowitz, it looked at the record and determined, even though the appellant had waived that argument, I believe in Berkowitz it was a passing statement to a Ferretta issue. Likewise, the record in this case shows that there is no procedural error, and both sentences are substantively reasonable. As to the procedural error, Your Honor, as it relates to the supervised release, without any objection from the parties, the court determined the grade of each violation, determined the criminal history category, calculated the policy statement range. The defendant admitted the violations during that, and the court confirmed after the arguments were permitted by counsel on the 3553A factors, the court confirmed both with the government and Mr. Peebles whether it had addressed all of the arguments in mitigation, and that was in the sentencing transcript on pages 15 and 16, and then again it reaffirmed that position on page 44 of the sentencing transcript. As it relates to the new indictment, which this court did a sentencing hearing, the district court did a sentencing hearing right after the supervised release hearing. It calculated the effective guideline range of 60 to 71 months, again with no disagreement from the parties. It allowed additional argument on top of what the parties argued in the supervised release matter. It addressed the relevant 3553A factors, and again, towards the end of the hearing at page 44 of the transcript, the court asked Mr. Peebles, who represented the appellant in the trial court, do either counsel request any further elaboration on my consideration of the 3553A factors? Mr. Peebles indicated no, and he also asked Mr. Peebles, are you satisfied that I've addressed all your arguments in mitigation to your satisfaction? To which, again, trial counsel in the proceeding below confirmed that he had. Your Honor, as to the substantive reasonableness of the sentence, in looking at the supervised release revocation, This court is looking to determine whether or not Judge Dugan's sentence was plainly unreasonable. This court has held that when we look at the on appellate review of supervised release sentences, this court has said that it is highly deferential and suggested that it might be comparable to the narrowest judicial review of judgments we know. Looking at the characteristics of the offender, Mr. Reynolds, in the district court, this was an individual who had twice been convicted of a controlled substance offense, distribution of a controlled substance offense, an aggravated battery offense where he shot a victim in the leg, and during the commission of the new offense was on supervised release for a federal felon in possession conviction in which he was sentenced as an armed career criminal. Your Honor, while there's been this discussion of a passage of time, and as best as I could get from the appellant brief, there was, I guess, an issue taken with the argument about the passage of time as it relates to Mr. Reynolds' criminal history, category, and calculation. The government's argument, which is contained in that sentencing transcript, is that it wasn't because of good behavior or law-abidingness that Mr. Reynolds' prior convictions for distribution as well as aggravated battery were not counted under the criminal history category calculation. It was because he was serving a 180-month term of imprisonment in the federal BOP. So understanding that now today there's this quality of time argument that Mr. Reynolds spent in BOP. The court addressed that sufficiently within the colloquy that he made with the parties in relation to the 3553A factors. He noted specifically in regards to the defendant's argument in the trial court about the rehabilitation aspect of a BOP sentence, and the district court rejected that, stating that Mr. Reynolds had just served a 180-month sentence in the federal BOP. He was out on supervised release when agents utilized a confidential source to purchase controlled substances from the defendant, and then upon execution of the search warrant, located a kilogram of cocaine as well as firearms in Mr. Reynolds' home. Your Honor, again, the appellant has really not pointed to any specific procedural error. However, I think the record in this court can see there is no procedural error, and the substantive reasonableness of both sentences was not an abuse of discretion. Your Honor, unless the court has any questions, we would ask this court to affirm the sentences in both the supervised release matter as well as the new indictment.
Okay. Hearing none, Mr. Caraway, thank you.
Thank you, Your Honor.
Mr. Peebles, anything you'd like to add?
I don't believe so, Your Honor. Thank you.
Okay, you're quite welcome. With thanks to both parties, we'll take the appeals under advisement, and we will move to our 8th argument of the day, and that is Martin Shokotahal Siello versus Pamela Bondi, the Attorney General of the United States.
Good morning, Your Honors.
Good morning.
My name is Laz Pittman, and may I please the court, Judge. Thank you for the opportunity to be here. In this case, appellant is arguing that the immigration court and thereafter the Board of Immigration Appeals ignored substantial evidence in the record, meritorious evidence that would have, if considered, at least rendered a good record for us to look at, a good decision for us to look at.
Ms. Pittman, you did not timely appeal the underlying merits. Your appeal here is limited to the motion to reconsider. Do you understand that?
Yes, Your Honor, although I was under the impression that once that under Mata v. Lynch, I may be wrong, that under Mata v. Lynch, once you appeal the motion to reconsider, it automatically merges.
No, our case law is clear and that you If you only appeal the motion to reconsider, you are limited to what was raised in the motion to reconsider. You don't go back to the original merits determination or the original determination by the Board of Immigration Appeals.
All right, Your Honor. Taking that into consideration, then let's look at the the decision of the Board of Immigration Appeals. In my
The motion to reconsider.
a motion to reconsideration, correct. Again, when the Board of Immigration Appeals dismissed the original appeal, it rendered a decision that was pretty scant. It did not. It basically did not point to the facts of what the judge had said or anything like that. Therefore, we went ahead and filed a motion to reconsider. And the decision on the motion to reconsider is also pretty scant. It also begs to question why the Board of Immigration Appeal only looked at the factors that the IJ had included, that the facts that the IJ had included. Now, I understand, and we are not asking that the Board of Immigration Appeals reevaluate or reweigh the evidence that the judge had included in her decision. What we are asking is what kind of standard did the Board of Immigration Appeals use? Because I really am confused looking at the decision on the motion to reconsider. Looking at that decision, I'm wondering why didn't the Board of Appeals ask the judge, what did you do with the remaining evidence? What did you do with the evidence about the 12-year-old child being sexually groomed by a 23-year-old man? How can you, I'm wondering, why did the Board of Appeals look at all of the record? What kind of standard did it use?
It sounds like you're going beyond the motion to reconsider now. You're going back to the original determination.
Well, I guess what I'm asking is, what standard did the board use in its decision when it rendered a decision on the motion to reconsider?
Yeah, here's the problem. I really think, going back to Judge St. Eve's question, that if you have a client in this situation, you have to petition from the original denial. You're in a very difficult position when you don't petition from that denial and you're only petitioning from the reconsideration denial. And the reason for that is because after MATA, if you take a look at our case law, and I'll give you a good example, Lopez Garcia versus Barr from 2020, 969 F. 3rd 749, we have said that the only thing that we can consider is whether the board's denial was without a rational explanation, was inexplicably departed from established policies, or rested on an impermissible basis. That's it. And it's very hard to look at this order because it is accompanied by reasons. It's not just a one-sentence denial. And then to figure out how that standard is met.
But it is my understanding that when the board reviews, if the board in fact really did consider its decision and reviewed the immigration judge's order, then how can the Board of Immigration Appeals completely disregard the remainder of the record and not really, what standard did the Board of Immigration Appeals use when it reconsidered its previous decision that actually said nothing?
Well, actually, counsel, I have both orders here from the board, and actually the motion to reconsider order is actually more detailed.
It is.
It is. It did address some of the IJ's findings. So I don't see that it's scant. right?
Correct. It actually, and I do agree, Judge, it actually does address the factors that the judge mentioned in its order. So the second order is much better. But then again, I have to, and maybe this is what you're pointing to, when it reconsidered its order, when the BIA went back and looked at the judge's order and say, okay, let me reconsider this, why and what standard did he use? We don't.
The premise of that argument is that they're under a legal obligation to apply a standard. Where's the legal obligation coming from?
Well, which standard did they use?
Why do they have to?
Did they use erroneous, clearly erroneous? Did they use de novo?
All they're doing is reconsidering what they did before, right? They're not in the first instance undertaking the review of the IJ's denial of the cancellation or removal. Again, that's why not petitioning from that has so boxed you in here.
And if I can go back to the court's position about having to review the original, or having to file an appeal to the first order, to the IJ's order. In the new case of Riley v. Bondi that just came out, it's the court saying that the first appeal was subject to a jurisdictional 30-day notice of appeal. Because as I understand, Riley v. Bondi, and maybe I'm wrong, Riley v. Bondi also said that the 30-day rule is not jurisdictional, but it's a
claims processing rule.
Yes, claims processing rule.
Right.
So I was also under the impression that that also extends this court's jurisdiction. In other words, I could not have appealed the motion to reopen. I could not have appealed the original judge's order until the motion to reopen the motion to reconsider was heard. So I was under the impression that Riley v. Bondi making this a claims processing rule does extend the 30 days of appeal from the first order.
We'll address some of this when we resolve this petition.
Okay, thank you, Judge.
You want to reserve any time for rebuttal after you hear from
yes, Judge, 1 minute.
government?
Thank you.
Okay, you're welcome. Mr. Least, good morning.
Thank you. May it please the court, Jeffrey Least appearing on behalf of the Attorney General. The board acted within its broad discretion in denying the motion to reconsider, and that is the standard the board has. It's a discretionary determination of whether or not an alien has presented an error of law or fact that would cause them to reconsider its prior decision. Now, this court has held that that is a very high mountain to climb. You actually have to give the board a reason to go back and reconsider its determination. The petitioner did not do so here. Briefly about the Riley issue, the petitioner is correct that it is no longer jurisdictional, the 30-day time period, but it is a mandatory claims processing rule. But Riley didn't do anything to overturn this court and the Supreme Court's long-standing precedent that you have to file a petition of each order that you're seeking to challenge. The petition for review here only challenged the most recent order, so you can't even try and get like a backdoor saying, oh, well, I challenged everything in that one. So to the extent the petitioner is trying to make an equitable tolling argument at this late in the stage, it's simply not applicable. If the court has any questions about the actual denial of the motion to reconsider, I'd be happy to entertain them, but I feel that the issue has been pretty well covered in the brief.
So if you want to challenge both the underlying denial of the cancellation or removal and the board's reconsideration of its ruling, you filed two petitions.
Yep, you could have filed one. I believe it would have been in July of 2014, and then after the motion to reconsider was denied, you would file a second one. And that's what Stone says, the Supreme Court's decision that 1252b6 is then those petitions are consolidated before the court. It's not like a preemptive consolidation.
But under B1, on the original 30-day period, the petition has to be filed within the 30 days.
Correct.
If you're going to challenge, and if not, you're
Right.
limited to challenging the reconsideration.
Right, and that's the only one that was challenged.
Because if it's not jurisdictional, it's still a claims processing rule, which leaves it up to one's adversary to choose whether you're going to enforce it or not. And here the Attorney General chose to avail herself of the protections of the time limitation.
Correct, Your Honor. We did file a 28J to note that it was no longer jurisdiction, and that to the extent it was applicable, we were not waiving the 30-day time period.
Yeah.
Riley also, given when the clock starts ticking, seemed to cut back on the possibility of an appeal or review rather than expand it.
That's correct, Your Honor. I mean, they didn't get into the issue of whether or not it could be told equitably, but at least from the majority's opinion, it suggests that it could not be told. So, thank you.
Okay, you're welcome. Anything further?
One of the things in this situation was because the original BIA order was so scant. We really wanted to exhaust the remedies and ask the BIA, could you give us something so we know what you're thinking? And that is why, that is why we went the route of motion for reconsideration rather than a straight appeal, because of the board's immigration, the order of the board, the initial order was so scant. Thank you, Judge.
You're quite welcome.
Thank you.
Thanks to you.
Okay, thank you.
Mr. Lees, thanks to you as well. We'll take the petition under advisement. You're welcome. That brings us to the last argument of the morning in appeal number 242488. Caroline, is it Matishek?
I said Madich, Your Honor.
Madich. Okay, I'll go with your, where's the Commissioner of Social Security? Mr. Tarlock, nice to see you.
Nice to see you, Your Honors. Good morning. May it please the court. Robert Tarlock on behalf of Carolyn Madich. Good morning to my esteemed colleague as well. Your Honors, I think there are two untraditional harms in this case and one traditional one. I'm going to start with the two untraditional ones. The first untraditional harm is that a medical expert was called in this case, and the medical expert said that in their years of testifying, they'd never been in this position before where they couldn't actually give the judge a particular listing, or in their words, a particular parameter within the Social Security Act to fit this person in, but they were clear on their opinion that this person was disabled and either met or equaled the listing. And they spoke to the time involved in treatment specifically. And when the judge pushed the expert at the hearing through cross-examination, the expert gave an example of frequent trips to the emergency room. And on cross-examination, the judge, administrative law judge, asked the medical expert, would these trips be necessary? And the medical expert hung on the opinion and said, yes, I don't see this as drug-seeking behavior. I do believe that there is an equaling or a meeting of the listing. And then further on cross-examination, and I was the hearing attorney at this hearing, I asked the doctor, it was the last question, given your total review of the record, what would be a reasonable amount of absences potentially that this person would have? And the doctor said Ms. Madich would miss at least 4 days of work given his review of the record. Now, as far as I understand the law, it is certainly Ms. Madich's burden to provide the evidence.
What else did, you're speaking about Dr. Shapiro, correct?
Correct.
Other than the plaintiff's own assertions, it didn't seem like Dr. Shapiro based that opinion on anything else in the record.
Well, we're only given his testimony, but as far as when he was asked by the judge, he gave one example, which was the frequent trips to the emergency room. He also mentioned, right before my final question about the potential absences, he said, I'd like to write to recover a listing. He said, but honestly, I just don't know how I'm going to be able to put this in more terms than I've already said, which essentially was him saying, and I want to quote this exactly, and this is on 1967 and 1968 of the trial record. I'm not saying there is no problem. I'm simply saying that her problem does not sit within the parameters that classify the listings of the administration. And then he goes on to say in direct quotes, I concur she meets a disability or equals a listing, because otherwise then we have failed collectively from a medical point of view to provide an adequate explanation for this lady's problems. Now, as I said, I do think it's Ms. Madich's burden to provide proof of her disability. But when a medical expert called by the commissioner comes and testifies and provides favorable testimony about someone's disability, there shouldn't be extra work on the claimant to then have to go and find out in testimony or in the record where that opinion would be more consistent or supported. Now, the judge did ask about necessity, but the judge did not inquire about which ones of these multiple appointments or these 4 days would be necessary, or how long would be a reasonable time. If it wasn't going to be a full day, how long, how many hours are we talking about here? The judge did not inquire. The judge rested her cross-examination. And I don't believe it should be Ms. Madich's burden to have to provide consistent and supportive testimony. It should be the judge's burden to find consistent and supportive testimony in the record to disregard that opinion on a functional ability of this claimant. That brings me to the second harm, and that was that the judge did not allow a full and fair hearing. And a full and fair hearing was not permitted because cross-examination and the opportunity to make a closing statement was not permitted by the judge. And in fact, during cross-examination, not only did the judge disallow questioning.
It was permitted, though. Cross was permitted, right? It was just cut short.
Correct. Cross-examination. There was an attempt to start cross-examination. However, as cross-examination got into a topic that this court recognized in Dimmitt is an actual area of concern, the occupational network, which the Department of Labor publishes, and coincidentally now footnotes in the new regulation, 24.3p, which was not applicable at the time, but just to the point that this court made in Dimmitt, it is an opportune topic to use on cross-examination. And as this court recently said in the Schmitz v. Colvin decision, questions about the source and methodology have to be asked at the hearing. Otherwise, you risk waiver unless there's really, I believe the court used obvious flaws within the VE's testimony. And in this case, the third harm was an obvious flaw because in this testimony, the VE says, well, I use this program called Skill Train. And in the few questions that were allowed on cross-examination, I asked the vocational expert, okay, how did you use Skill Train? And the expert said, oh, there's a methodology statement on the internet. You should check it out. I said, I'm familiar with that. That statement lists 3 different ways you can use the program. And the VE said, well, I use the total distribution method. And as we fleshed out at the hearing, the total distribution method just takes the total number of jobs in each occupational category that the Bureau of Labor puts out. And this court addressed the problem with that specifically in Runger when you don't have any type of matching detail involved. And when that testimony is challenged, which I think you can read from the record, I was clearly trying to lay a record of both developing the cross-examination and then to be able to make my impeachment of the witness. But I was not permitted to do so because the ALJ wanted to get lunch. And I understand time constraints on these judges, but this was a telephone hearing. There could have been opportunity to have it later in the day. There could have been opportunity to say, I'm running late for lunch. Please wrap this up. You have 5 minutes. If you have any possible topics of rebuttal, make your closing examination. I'll give you time in post to hit anything. But there was none of that.
But then you were, after the hearing, right, you were allowed to submit in writing some objections to the use of Skill Train and the Job Browser Pro application?
I wasn't allowed to. I did submit, and they were exhibited, but it was based on an incomplete record because I wasn't able to actually develop the testimony that I wanted to use, nor, importantly, ask the hypothetical questions, particularly from the previous administrative decision that were pertinent in this remand hearing, as well as from some of the limitations that were from the state agency doctors and a previous psychological assessment as well. So there were meritorious questions that may not have been prevailing on the judge, but because the judge didn't allow a full and fair hearing, all of the rebuttal is based off an incomplete record. So it's sort of like playing poker against somebody, but then you're not allowed to use all 52 cards in your deck and saying it's a fair game, you had your shot. With that, Your Honor, I'd like to reserve my time for rebuttal. Thank you very much.
Okay. You're welcome.
May it please the court, Meredith Schacht on behalf of the Commissioner of Social Security. I'll start with the second argument first. The ALJ did not err at step 5 in this case. Ms. Madich was permitted ample time. It's true that the ALJ cut off questioning at some point as she had run out of time, but under the circumstances here, as counsel's acknowledged, questions were asked. He asked the source of the testimony. He asked what methodology the vocational expert used, which she answered in reference to a website and in conversation with counsel, identifying that she was using this total group approach. There's no question what her methodology was, what her source was. All of that information came out during the hearing. The ALJs are subject to time concerns and incredible workloads. So yes, she did have to cut the hearing short at some point to move on to more hearings. But under the circumstances here, there's no information that was missing. Counsel indicated that when he got to an area of importance, he was cut off. But the area where the ALJ actually cut him off was when he started asking about ONET. He asked the vocational expert, is ONET reliable? She said, I sometimes use it. He asked another question, and she said, I haven't used it here. I did not rely on it, had no part of my testimony here. And then he continued to ask about ONET, and the ALJ said, let's be clear, you didn't rely on ONET today, right? It's not relevant to your testimony here today, and the vocational expert confirmed that. So the ALJ here cut off testimony when it started veering towards something that she established was not relevant. It was not erroneous for her to do so under these circumstances. The vocational expert here, sort of more broadly on step 5 issues, the vocational expert was well credentialed. She identified common jobs, and the ALJ explained that agency policy and the medical vocational guidelines that are laid out and governing, controlling on the ALJ here also indicated that there were jobs available, essentially answered the step 5 question even regardless of the vocational expert's testimony. So under no circumstances was there harmful error at step 5 in this case. Similarly, there was no error in considering Dr. Shapiro's testimony. It's clear that Dr. Shapiro thought that the number of appearances or the number of times that Ms. Madich went to the hospital would preclude her from working. But he could not identify a reason that she had to go to the hospital. The ALJ is obliged to make a finding based on medically determinable impairments. She asked Dr. Shapiro, can you identify a medically determinable impairment that was imposing your opined limitations, and he could not. He identified some minor restrictions based on asthma, and that was the only restriction that he could tie to a medically determinable impairment. So the ALJ explained very well in her decision how she considered Dr. Shapiro's testimony. It actually provided a framework for much of her 24-page decision. She noted a lot of his testimony, and she did actually accept a lot of his testimony that these hospital appearances did not have a medically determinable impairment that explained them. She was not required to do anything more than she did in her decision. Her decision was consistent with the governing regulations. For residual functional capacity, as I said, was required to be related to a medically determinable impairment, which Dr. Shapiro couldn't provide here. So both the ALJ's assessment of Dr. Shapiro's opinion and the her step 5 conclusion were supported by substantial evidence. So we would ask that you can affirm.
Jack, do you have time can I just ask you one question just to understand something? I know it's not before us, neither side is raising it, and that is this. Everyone is clear that the limited question before us is whether Ms. Madich was disabled before she reached the age of 55.
Right.
When she reached the age of 55, she was either deemed or determined to be disabled. How does that work?
So that's actually under those medical vocational guidelines that I referenced and that the ALJ discussed in her decision. They set out essentially a framework that in some circumstances require either a disability finding or a non-disability finding, or in some circumstances suggest one or the other. So those rules laid out in Appendix 2 of Section 404.
But does it hinge upon one's physical and mental abilities? It's not just that everyone that reaches the age of 55 is disabled.
No, it's set out. They're called the grid rules because there's essentially, I think, 4 grids, and it's based on exertional ability first. So there's a grid for heavy. You have no exertional limitations, I think, or there's a grid for medium exertional work, for light exertional work, or sedentary work. In this case, the governing rules were in that section of the appendix that addresses light exertional work, and then within that it divides based on age, and then based on education, and then based on prior work history.
Okay, I follow you. Thank you.
Thank you so much.
You're welcome. Mr. Tarlock, you got a little time left if you want to use it.
Thank you, Your Honor. I appreciate it. Just briefly respond in order to the points that my colleague made. First, at no time during the hearing did the judge ever say that timing was an issue, either at the beginning of the hearing or after the medical expert or at the beginning of cross-examination. The judge did ask 5 hypothetical questions, and some of those hypothetical questions were outside of the grid. So it's not as if I threw on limitations in ultimate questions that I was pulling out. It was the judge who asked a question which would then require some cross-examination to deal with if you're not going to rely on the grids. And the judge did go on the record and say, I'm going to rely on the grids when she turns 55, but the judge did not say anything about relying on the grids prior to 55 that could have given me as the counselor a heads up of where she was leaning. It's her right to do so, and it probably could have given me less of a reason to cross-examine and more of a reason to go to my closing argument and make a rebuttal. But because she didn't do those things, Ms. Madich was harmed in that result. The government brings up the use of SkillTran and the ONET. If somebody is using SkillTran, then they're using the ONET, and that's in SkillTran's own documents. In SkillTran's methodology statement and in their materials, they have the ONET in the center of their Venn diagram. So my questioning on the expert was going to be, I don't understand, if you use the ONET and you're using SkillTran, there's unclarity there. They can't be, they're symptomatic with each other. They depend on each other. So that was a reason to cross. And I also wanted to ask about what the ONET says the SVP levels are. Because I did let the judge know in my post that the range in those occupational groups are higher than an SVP2. So where this notation of unskilled work comes from is important, particularly when we're dealing either with some of the mental restrictions that the remand order and that were in previous restrictions and the judge's third hypothetical, or just unskilled work without the transferable skills, which was also material. So that is why the ONET, other than being part of the source and method, should be an opportunity to be explored upon. The government also mentioned this total group method, but that is not a method or a distribution. That's just taking an entire amount of jobs within an occupational group. No exertional erosions, no skill erosions. And again, this court has pointed out you might be able to do that. For example, it's like the equal distribution method, but there needs to be evidence of why that's reliable. The judge didn't ask that question, and I asked the judge in the beginning of the hearing on 2180 before the hearing to ask that question in this case. Thank you, Your Honors. Thank you.
Mr. Tarlock, thanks to you. Ms. Shack, thanks to you. We'll take the appeal under advisement, and that concludes today's arguments. The court will be in recess. Thank you.